So several of you have pinged me asking for an update like this one. It has to do with the administrative stay that Judge Roberts had issued several days ago regarding the application that former President Donald Trump filed with the Supreme Court, asking the Supreme Court to block the release of the tax documents that should be reviewed by the House Ways and Means Committee. I didn't really give a full review of this because the response from the Department of Justice has been filed. It's this one that you see behind me, and the reason I didn't do a video about it is because it's a fairly mundane 29-page response from the Department of Justice, basically asking the Supreme Court to remove the administrative stay and reject the request, the application from Trump. I think two passages are most important to tease out of this, and one of them is the one behind me. In it, the Solicitor General, who filed a response on behalf of the DOJ, obviously, and the IRS, is saying that for about 100 years, the court has been basically staying away from squabbles between the legislative and the executive when it comes to the request to provide documents that fit and fulfill a specific legislative purpose. It cites one case from 1975. It is Eastland versus United States Servicemen Fund. And then it talks about the Mazars case. And the Mazars case that you see behind me is the one that was submitted back in 2020 to the Supreme Court that was basically asking the court to decide whether a subpoena issued to Trump's accounting firm, compelling it to issue non-privileged financial documents, was in fact constitutional. And the result, it was a 7-2 decision. The result was that the lower court's decisions that were being brought before the Supreme Court were vacated. They sent him back to the lower courts for another decision, and the lower court issued another subpoena. Now, why am I telling you all this? Because the Solicitor General, in its response last week, is pointing out that the Court of Appeals that issued the decision that is now being appealed to the Supreme Court didn't even question whether Mazar was applicable. It was in fact applicable, and therefore, if the lower courts in the previous case could issue a subpoena regarding financial documents, then so can the DC court in this case that is being appealed to the Supreme Court. So essentially they're saying it's not even a question of if it's been done in the past, it should be done again. A lot of stuff to fit into 3 minutes. I hope that was clear and I didn't confuse you even more. Obviously, we'll now wait and see what the Supreme Court says, so stay tuned.